So, Catherine, is that everyone?
I believe that is everyone, Judge.
Okay. Can everyone see and hear me okay?
Can, Judge.
You can.
All right. So the court has on its docket this morning cause number DF 15-09887-S, styled in the interest of JADY and JUDY children in the 301st Judicial District Court. I am sitting by assignment from the presiding judge of the First Administrative Region. My name is Jim Jordan. I'll be presiding over the motion to recuse that has been filed in this case by the movant Jeffrey Damon Younger. Let me ask the parties before we begin if they'll make their appearance for me on the record.
Craig Jackson for Jeffrey Younger, the movant in the motion that's before the court.
Thank you.
All right, and then I'm Jessica Janasek, and I represent the respondent, Dr. Ann Georgelis.
Thank you.
And Logan O'Neill on behalf of the movement, Your Honor.
All right, just a moment, please. All right, anyone else?
No, Your Honor.
All right, so Mr. Jackson or Mr. O'Donnell, who's going to argue on behalf of the movement?
I will be, Judge.
Okay, thank you. All right, so here's what I have. I have the motion itself, the motion to recuse. It was filed on, I believe, March 26th.
That's correct.
I also have a response that was filed this morning, March 29th. And I also received a motion for continuance and for leave to subpoena judge that was also filed March 29th. Anything else that was filed that pertains to the hearing that I have not identified?
None of which I'm aware, Judge.
Right?
No, sir.
All right, thank you. So let me start by, I guess, starting with Ms. Janasek. Have you had a chance to review the motion and leave for subpoena?
I did, Your Honor. I had a chance to review that today.
Okay, and so what's your position on that? Are you unopposed or opposed?
I don't believe I have any position with regards to, well, I have an opposition to a continuance because this hearing has been pending for 2 months. And we've also, on top of that, Your Honor, the issue at hand occurred back in August of 2020, so 7 months ago.
Okay,
So
well, hang on a second. Before we get into an argument, I just need to know whether you're opposed or unopposed.
I'm sorry. I'll say I'm opposed. I'm not opposed to them subpoenaing witnesses if they want to subpoena witnesses, if that makes sense.
Well, they in the motion, they've asked to subpoena the presiding judge.
And I would just simply object if that's going to create a continuance at this time.
Okay, so let me, Mr. Jackson, let me go back to you on the motion to continue. And I got, I guess, a couple of questions first. You cited in support for your motion to continue Texas Rules of Civil Procedure 18A, subsection G, subsection 5. And I guess I'm looking at subsection 6, the very following, which talks about the hearing, and then paragraph A, time under that. Do you see where I'm referring?
I do, Your Honor.
Okay. And it says the motion must be heard as soon as practicable and may be heard immediately after it is referred to the regional presiding judge or an assigned judge. So under this rule 18A, does it provide, first of all, does it provide for a continuance? And second of all, if it does, what are the factors that would allow for a continuance?
Sure, Judge. If you look at, well, first of all, I cannot issue a subpoena to a presiding judge without leave of court. I mean, that's to either be decided by the presiding judge or the judge assigned under 18A G5. So under 18A G5, this court and you, Judge Jordan, can determine whether we may issue a subpoena. Now, under subsection 6, which you quoted, yes, the court says it must be heard as soon as practicable. And I would submit that it wouldn't take very long. And this is a motion that we were loath to bring. It's just that once that amended pleading was filed on the 24th of March, making that, if believed, makes Judge Brown a material witness potentially. And so there is no way under the sun for us to obtain the evidence that she does or does not have knowledge of relevant facts without taking a 10 or 15 minute deposition. It's not, again, it's not something we were itching to do, but once it was the events that were laid forth in the March 24th amended pleading sort of weaponized this whole event that occurred back in August, we had no choice but to find out whether Judge Brown does indeed have knowledge of relevant facts. And so if you take that subsection 5 and subsection 6 together, the only way they can be harmonized is that if the court does allow discovery, meaning a very quick deposition, or allows us to subpoena the judge, we can have a hearing as soon as practicable, but that date would be on the flip side of either taking that short deposition or shortly after subpoenaing the judge. So if this were a case in which a motion to recuse were filed months before a trial, there would certainly be time to have a motion for the administrative judge to allow for a subpoena or allow for some discovery, but we just did not have that time here. So to harmonize 5 and 6, all we're asking for is a brief recess to allow us to find out what Judge Brown knows. And if that testimony is, I don't know anything, well, then that puts the kibosh on the motion itself. If, on the other hand, she does have knowledge of material facts, then that's a different issue. So I guess your question, as soon as practicable, is on the flip side of finding out exactly what Judge Brown knows.
All right. So paragraph 5 states, though, except by order of the regional presiding judge or the judge assigned to decide the motion, which I guess would be me, a subpoena or discovery request may not issue to the respondent judge and may be disregarded unless accompanied by the order. So I guess I have two questions. One is, clearly, it's saying that the judge, that only I or the administrative judge can subpoena the judge to this hearing. So my first question is there a mechanism that you're aware of that allows one of the parties to request a subpoena from the judge? And second of all, if there is, or if I was to consider issuing a subpoena, which says that that's the only way she's going to be called as a trial witness at this hearing, what are the factors that I am to look at to determine whether or not such a subpoena should issue?
Well, I think just as in any issue in which a motion for continuance is requested, I believe that the court has significant, if not almost absolute discretion over its docket. Here we have an issue, though, where due to no lack of diligence on our part, we have a witness that cannot be subpoenaed whatsoever to testify either by way of a deposition or live in the hearing without leave of court. So I would submit that as far as factors go,
Well, the first question I had is it doesn't say upon leave of court you can subpoena her. It says that I have to order it.
well, I would submit that except by order of the regional presiding judge or the judge assigned, a subpoena or discovery request may not issue to the responding judge and may be disregarded unless it's accompanied by the order.
So what factors, do you have some case law or statutory authority that tells me what factors I have to consider when deciding whether or not to issue such an order?
Well, I would submit that the case law is replete that the foundation of any evidence has to be based on personal knowledge. And we will not have a witness, and we have no access to a witness with personal knowledge unless that witness is indeed Judge Brown. So again, the whole basis of our motion is that we need a witness with personal knowledge, and the only way to obtain that is with an order from this court that would accompany the subpoena that it would issue. So with respect to case law or statutory authority, I would submit that 18A subsection G5 gives you the authority to issue the order. And with respect to the actual subpoena we're seeking here and the information we're seeking, it can only be obtained by Judge Brown. I don't know that there's any other relevant factor other than we learn of needing, we received the second amended pleading that contains the allegations that Judge Brown does have personal knowledge after hours on Wednesday evening. And so we diligently filed our motion to recuse. Again, the only grounds listed are that she now appears to have personal knowledge of some relevant facts. It's just not a case. It's not a case where we have a record of something already being said on the record, which might normally be attached to a motion for a recusal. We have a judicial admission effectively by the petitioner stating that the judge does have personal knowledge. So,
so let me ask you this, because if I'm hearing you correctly, you're stating that you want an order from me issuing a subpoena for her to appear and testify. And as you stated, to find out whether or not she has personal knowledge, and if so, what personal knowledge does she have?
correct.
But if we don't know whether or not she has personal knowledge, why has the motion been filed?
Well, I mean, motions for recusal can be brought upon information and belief as well as personal knowledge. But with respect to, we were put on notice that she may have personal knowledge on Wednesday night. That the issue, the event and allegations at hand were not put into a pleading or otherwise made an issue in this case until Wednesday night. And so, as far as I know, the petitioner has some source of knowledge that the judge has personal knowledge of the events. And
yeah, I was going to say, your client has verified that he has personal knowledge, that she has personal knowledge.
Well, he's verified that she has personal knowledge based on the allegations that are in that pleading.
Okay, so the statement says that the pleadings have established that she has personal knowledge. Grounds for recusal. The petitioners filed pleadings in this case that establish that Judge Mary Brown has personal knowledge of disputed evidentiary facts. And then your client signed off on it declaring that he has personal knowledge of those allegations and facts.
That's correct.
Okay. So let me just ask one more question. I know that it got filed on the 26th, but it was served on the 24th. Is there any reason why there was a 2-day delay in getting it filed?
Oh, no, their second amended pleading was filed on the evening of the 24th. And then our motion for recusal was filed
Okay,
on.
I got you. I'm with you. Okay. All right. Well, here's what I'm going to do. I'm going to deny the motion to continue. And I'm going to go ahead and hear the motion to recuse, but I'm going to reserve a decision on whether or not I feel it's necessary to subpoena the judge to testify until I've heard the argument and any evidence that's presented at the hearing.
Well, then we're going to have a very short presentation, Your Honor, because my client wasn't present at the alleged protest, and I don't know that anybody in this hearing was. I suppose I can call Ann Georgelis and see how she has knowledge of the protest that she complains of in her pleading. So,
And respectfully, Judge, I just,
Well, hang on a second. I just want to
I'm
make sure
sorry.
Mr. Jackson's finished.
I apologize.
That's okay. Go ahead, Mr. Jackson.
you know, I would submit that we'll call Ann Georgelis to the stand.
Okay. All right. So, Ms. Janasek, there's something you wanted to say?
Yes, I apologize. I don't mean to interrupt. I just wanted to point out that at no time did the pleadings say that Judge Brown has any personal knowledge of anything in this case outside of what she has heard in the courtroom. Our pleadings that we amended this past week specifically state that Mr. Younger and his supporters and his girlfriend, who was present at this rally, who I tried to subpoena and would not, I couldn't get her subpoenaed here, but this is not my motions, it's Mr. Jackson's motion. But I would like to point out that the pleadings themselves do not allege that. They allege that Mr. Younger, by providing information online to his supporters who posted it online, and I have this in my response, Your Honor, that what they did was they attempted to have ex parte contact. At no time do I state did they have any contact with her or that she has personal knowledge. It was just simply to show that these protests continue repeatedly, because it's not just with Judge Brown, it's with everyone. So I just wanted to clarify that because I didn't want the court to think we had alleged that she had personal knowledge.
So my inclination is to, and my feeling is that I want to comply with the rules to have the hearing as soon as practicable, which can be immediately, and that the judge is not going to be subpoenaed to testify at the hearing unless I so order it. And I'm a little reluctant to do that on just an allegation that we don't know exactly what she knows. She may have personal knowledge, she may not. So I'm prepared to go forward with a hearing, although I think I'm going to have to hear some evidence or see some evidence that she does indeed have personal knowledge of disputed evidence on the presumably on the upcoming petition that has been filed and then I guess amended, seeking to modify the parent-child relationship and clarify appointment of family counselor, or in the alternative, modify family counselor provision. That's what's coming up that you're seeking to have her recused from.
That's correct, Judge. And again, here's the difficulty with this is we have an allegation that my client is attempting to ex parte the judge by organizing and orchestrating these protests. We have allegations that he is having supporters contact the judge and let her know that the trajectory of this case, I presume, is not acceptable. My client has denied and disputed those allegations. My client has, he can testify that he has no knowledge. His testimony would be he has no personal knowledge of these allegations because he wasn't a part of them. So I can put him on the stand and ask him 100 different ways how much he knows about this, and his answer is going to be, I don't have any personal knowledge of it because I did not orchestrate the protest. I did not have direct supporters to harass Judge Brown. And that's about all. He would certainly not establish by his testimony that Judge Brown was harassed or ex parte. The only other witness that could offer anything to that issue is Judge Brown herself. And again, like I said, I have 24 years of doing this, never attempted anything like this or needed to, and would have addressed it sooner had we known sometime before Wednesday night of last week that this was an issue. Again, I would request that, there's no competent evidence that we can put on without her as to this specific issue. And so as far as the soon as practicable, and it may be held immediately, it doesn't say it shall be held immediately, just as soon as practicable. And again, I would just re-urge that as soon as practicable is after we can find out what Judge Brown knows.
As I said, I'm going to deny the motion to continue. I will hear the motion to recuse in whatever evidence that you want me to hear in that regard. And if I hear some evidence that I believe requires that Judge Brown be subpoenaed in order to appear to give her testimony, then I'll consider whether or not issuing such an order. But I'm going to hear the motion first. Let me put it this way. I'm not going to grant the order right now. I'm not going to say I'm not going to. I'm going to hear the motion and determine whether or not I feel that's necessary.
Very good. May I call it?
I was going to give both parties a chance to have an opening statement, but I kind of feel like I've heard what I would hear in the opening statement. So I'm ready to go to the evidentiary portion if the parties are.
Very well. And I would ask the court to take judicial notice of the motions on file that you referred to earlier.
Yes, I can take judicial notice of all the pleadings and orders that are in the file.
And I'd call Ann Georgelis.
Okay. Is she, oh, there she is. Okay.
Figured it out. I figured out how to hit the right buttons.
All right. If you'll please raise your right hand for me. Under penalty of perjury, do you swear or affirm that the testimony you give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
All right. If you'll give your full name for the court reporter, please.
Ann Georgelis.
Okay. And you're the movant in this matter. You're the one moving for the you're seeking the relief of the recusal.
No.
No, she's my client, Your Honor.
Oh, I'm sorry. I've got okay. So you're the one that's opposing the relief. Yeah.
Correct.
Okay. All right, Mr. Jackson, I'm sorry. I've got it straight. Go ahead.
State your name for the court, please.
Ann Georgelis.
And last Wednesday, you signed an affidavit that's attached to what is styled your second amended petition to modify the parent-child relationship, second amended motion to clarify appointment of family counselor, or in the alternative, first amended motion to modify family counselor provision. Is that correct?
Yes.
And in that affidavit, well, let me ask you this. Did you read that affidavit before you signed it?
Yes.
Okay. And in that affidavit, you stated that since the entry of the final order in this case in January 2020.
Mr. Jackson, do you mind? I've got the affidavit, but it's lengthy enough that if you could identify for me where you're reading, I can follow along.
Okay, Judge. It is on page well, the first part I'm reading is Exhibit A, let's see, page 9 of the motion itself, Judge.
Oh, okay. It's not in her affidavit?
Well, I was going to ask her about her motion, some allegations in her motion first, and then the affidavit as well.
Oh, okay. All right. Go ahead.
in that motion, you've said, since the entry of the final order in this case in January 2020, that you've been unable to enroll the children in extracurricular activities without Jeff Younger telling his supporters about the location of the child's activities. And then you further state that on August 17th, 2020, just 2 hours after Jeff was notified about the kids being enrolled in school, there was information posted on the Save James Facebook page asking supporters to call the facility and to contact the judge and let her know that this is not acceptable. You recall that being in your motion?
No. But does it say after being enrolled in school? That seems like
Yeah.
that's not the right word.
You recall on August 17th informing Jeff that you'd enrolled one of the children in dance classes and
Yeah, dance, not school. So that's the part that I was very confused.
Okay, if I misread, I was trying to be short and I may have left that important part out.
Right.
So forgive me on that. And then shortly after that, you recall information being posted on the Save James Facebook page asking supporters to contact the judge and let her know this is not acceptable.
Forgive me if I'm wrong. I don't know. I can't pull up that where you're and do a Zoom. I'm just not that technologically advanced. But I think that what they did was they wanted to contact the dance studio. I don't know the wordings. It might also have said the judge. I don't remember, honestly.
Okay. Now, in your affidavit, though, on page 8 specifically, you have said that Jeff has organized and has supported organizing attempts to provide ex parte contacts about this case with the court by having supporters of his movement show up at the court's personal home in an attempt to bully and harass the court to get his way. Do you recall reading that?
Yes.
Okay. How is it that you know that Jeff's organized and supported and organized attempts to provide ex parte contact about the case with the court?
I only know that is, in my belief, what is suggested from the behavior that I have seen from this Save James Facebook page and the postings that have occurred before, during, and after that are on that page, particularly related to the protests in front of the judge's house.
So you've seen something indicating that there was a protest in front of the judge's house?
Yes.
What did you see in that regard?
There were live video streams.
Were you watching that live?
I did watch it live.
Okay, and what did you observe there?
I observed that there were people, approximately 20, but I could be off by a factor of 2, protesting outside of the judge's house.
Did you know any of the people that you saw congregated?
I know of 2.
Were either of those 2 Jeffrey Younger?
No.
Okay. Did you see Jeffrey Younger among any of the people in that crowd?
No.
Did you see anyone come out of the house on the video?
No.
Did you see anything that indicated that people in the crowd were interacting with someone that might have come outside of the house?
No.
Have you seen video that purports to show the judge or her husband or any other family members coming outside of the house?
Yes.
And where'd you see that video?
Several days or maybe up to 2 weeks later, there was another video posted.
And what did
I don't know where it was posted. My more technologically advanced daughters sometimes show me these things. And it was the judge's husband, or I assume the judge's husband, and a follower of Save James, whose name is Kevin Witt, having a conversation outside of her house.
And what was said in that conversation?
Well, the judge's husband was saying he wasn't allowed, the man wasn't allowed to protest. And there was an argument about that. And then the judge's husband at one point asks the guy what his end game is. I don't remember all of the details, of course, but.
Is there any swearing involved?
Not that I remember.
How long did that encounter with the judge's husband last?
It's a couple of minutes of the video. There was a point where it was cut and then resumed, but a couple of minutes.
And so what, you mentioned that the judge's husband indicated or asked, what's the end game? What was the response to that?
I don't remember.
Was the discussion between one of the protesters and the judge's husband heated?
Initially, but not for more than a few seconds.
What happened after the judge's husband re-entered the house?
I don't think they showed him re-entering the house, but if they did, I didn't watch to that extent.
And do you know what Judge Brown looks like?
Yes.
Did you ever see anything that gave you any reason to think that she saw the protesters out there?
No.
Okay. I'll pass the witness, Your Honor.
All right, cross-examination.
I have no questions of this witness, Your Honor.
All right, thank you. Witness, normally I'd say may step down.
I would like to reserve the right to recall her after I question my client.
As a party, though, she's welcome to stay in the Zoom hearing.
Absolutely.
All right, Mr. Jackson, additional witnesses.
Call Jeffrey Younger.
All right.
Jeff, you heard
Hang
your.
on one second.
pardon
Mr.
me.
Younger, if you'll please raise your right hand. Under penalty of perjury, do you swear or affirm the testimony you give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, all right, Mr. Jackson, go ahead.
Can you state your name for the court, please?
Jeffrey Damon Younger.
And you just heard your ex-wife's testimony, is that correct?
Yes, sir.
And let me ask you this. Did you have any involvement in organizing any protest outside of the judge's home?
No, sir.
Have you heard that there was a protest outside the judge's home?
Yes, sir.
And have you seen any of the video that your ex-wife just referred to?
Yes, sir.
And as far as the protesters go, do you know any of those persons individually?
Yes, sir.
And who were in general terms, who was there that you knew?
Members of my church. It looked like activists from the transgender community who have desisted and are now against the practices of transgender child abuse. And there were some political activists there. I think even there was a political candidate there.
As far as what sparked the protest outside of Judge Brown's home, did you know that the protest was going to occur before it occurred?
I think I saw it on the Save James page before it occurred.
Well, let me ask you about that Save James page. Is that are you an administrator or founder of that particular page?
I am not.
Do you have control over what's on that page?
I do not.
Do you have, notice that you were accused of being responsible for strike that. Have you read the portion of your ex-wife's second amended petition wherein she quotes that the Save James Facebook page asks supporters to call the facility and contact the judge? Have you read that?
I have read that.
Did you have anything to do with that particular post?
No, I think that's counterproductive.
And have you encouraged anyone at any time to contact the judge and let her know that anything is unacceptable?
No.
As far as the protest outside the judge's house goes, you have any way of actually having personal knowledge of what went on there since you weren't there?
No, sir.
All right. We'll pass the witness, Your Honor.
Thank you. Any cross-examination?
No questions, Your Honor.
All right, thank you. Mr. Jackson, any additional testimony?
I have no additional testimony, Judge, but I would like to ask for leave to further amend our motion for recusal based on Dr. Georgelis's testimony. And this would go hand in hand with our request for a continuance.
Well, hang on one second. Before we get to that, is there any additional evidence that you want to?
I have no additional witnesses or evidence, Judge.
Right. Ms. Janasek, do you have any evidence that you want to introduce?
I do not. I would like to ask for a directed judgment at this point because
Okay,
the
well,
evidence.
hang on just a second.
Sorry.
All right, so I'm going to, so the evidence portion of the hearing is closed. I will hear argument, beginning with Mr. Jackson. Ms. Janasek, you may have a response, and then Mr. Jackson, you can have a brief rebuttal. But how much time do you feel that you need to argue the motion to the court, including what amendment you're about to ask for?
I would think 30 minutes to an hour.
To argue?
Oh, I'm sorry. I thought you meant to actually have the hearing on the motion to recusal if it were to be continued.
No. The argument on what I've heard so far on the motion.
Oh, 2 minutes.
Okay. Why don't I give you, you can take 5 and have 5 in rebuttal. Ms. Janasek, you can have 10 in response. And there's no requirement that you take all the time. Does that work?
Absolutely, Judge.
Okay. All right. Go ahead.
Judge, first of all, I would ask the court to, when it's considering whether to grant the continuance, to take into account that Ms. Dr. Georgelis's testimony that the judge's husband was interacting with the protesters. That implicates an entirely new provision that's within Rule 18A, which is, 18B, which Rule 18B contains the actual grounds for recusal. 18A sort of lays out the mechanism. And if you look in 18B, subsection B7, in that provision, it says the judge or the judge's, a judge may recuse any proceeding in which the judge or the judge's spouse or a person within the third degree of relationship to either of them is known by the judge to have an interest, is to the judge's knowledge likely to be a material witness in the proceeding. So based on the allegations that are laid out in Dr. Georgelis's second amended petition, now, in light of Dr. Georgelis's testimony this morning, it appears that the judge's husband has knowledge of relevant facts and is likely to be a material witness in the proceeding. And so I would re-urge that based on what you've heard, The grounds that we pled were that the judge has personal knowledge of disputed evidentiary facts concerning the proceeding. The disputed facts are that my client attempted to make ex parte communications by organizing a protest. He has disputed those facts. The only way to actually have competent evidence, though, to establish what the judge actually knows, again, is to have a few minutes of her testimony as to what she knows. And again, additionally, now that we know that the judge's husband was involved in this, and again, I'm not attributing anything, any kind of malice on either the judge or the judge's husband's part, but if the judge's husband is likely to be a material witness, that also would lead Judge Brown to be subject to recusal. So again, I'm urge that the court give my client the ability to actually have his day in court on this motion, allow us to, again, take the brief deposition or call her to the stand. It shouldn't be particularly dramatic or traumatic. We just would like to know what she knows of the protests. And in light of the importance of this case, and in light of the fact that time is not of the essence with respect to this case, we don't have a trial date. We don't have anything urgent. There's no emergency at present. It would absolutely be fitting with the notion of justice and fair play to allow and due process to give us the opportunity to find out what Judge Brown knows.
So remind me of the testimony that we just heard. She saw the husband come outside the house and mentioned to one of the protesters that they didn't have the right to protest on his property.
That's correct.
Any other discussions that was part of the testimony, or was that largely the testimony of what was said by the husband?
Well, and this is my first time ever laying eyes or hearing Dr. Georgelis, and I'm new on the case, but I know of nothing. I don't know what the substance of those communications was. Hence, at this point, we would also want to find out what Judge Brown's husband knows. I don't think we need leave of court to pursue that. But my point is that now that's issue is entered my sphere of knowledge, then it would be the most practical and fair thing to do would be to, again, allow us to find out, A, what Judge Brown knows, and I would submit that we would request for leave to amend our motion to add that on information and belief, Judge Brown's husband may have knowledge of of relevant facts. So again, we're not asking for.
Well, that's okay. All right. All right. Anything else? Go ahead.
And again, I'm certainly aware that opposing counsel is going to ask for a ruling in their favor as a matter of law because there is not evidence in front of the court per se as to what Judge Brown knows. And I can appreciate that, which is why from the get-go we sought leave to find out what Judge Brown knows, because really in a case like this, we are absolutely between a rock and a hard place as having any ability, unless the judge says something on the record, there's only one way to get there, and that's through the subpoena that we've requested and which the rules contemplate.
All right, thank you. Ms. Janicek?
Yes, Your Honor. I'm going to try to be brief, but I think Mr. Jackson said it himself. There is no evidence in front of this court that Judge Brown has any personal knowledge of anything or did anything wrong. Rule 18A subsection A very specifically states that your motion has to state with detail and particularity the facts that are within the affiant's personal knowledge, would be admissible in evidence, and if proven, would be sufficient to justify recusal. Even if Mr. Younger had not waived any of this, which I'm going to argue just a second, he doesn't even meet the pleading requirements because his own pleadings state that he has personal knowledge of what he speculates, but he said today he doesn't have personal knowledge of any of that. And Mr. Jackson just said, there's no evidence in front of you that Judge Brown has personal knowledge of anything. On top of that, this whole testimony about the video that's there, that rule that Mr. Jackson is referring to talks about a material witness, not just a personal knowledge, material witness. There is a video out there of supposedly of Judge Brown's husband talking to another witness. It's on video. There's absolutely no reason to say that he would be a material witness either. And the last thing that I would point out, I think, is the court doesn't even have to get to the merits of this, because under Rule 18A subsection B, there is a section that says the motion to recuse has to be timely filed or it's waived, regardless of what the allegations are. And I would point out to the court that this motion to recuse was not filed at least 10 days before. It was filed less than one business day before. And for Mr. Younger to make the allegation—
Hang on a second. The motion to recuse was filed one business day before what?
The hearing itself. So the rule says that it must not be filed after the 10th day before the date set for trial or other hearing, unless before that day, the movement either knew nor reasonably should have known that the judge would hear the motion or that the ground stated in the motion existed.
Okay. So doesn't it appear that that's referring to the hearing from which they want the judge recused and not the recusal hearing itself?
My understanding from the rule is that it has to be at least 10 days before it says or other hearing, unless before that date, the movement neither knew nor reasonably should have known that the judge whose recusal is sought would preside at the trial or hearing.
Okay. So my understanding, though, and I asked Mr. Jackson about this, was that the motion was filed because they wanted to recuse the judge from hearing anything pertaining to the petition you filed on March 24 to modify the parent-child relationship, clarify appointment of the family counselor, or modify the family counselor provision. Has that been set for hearing?
Yes, that was actually set today at 1:30.
Okay.
So that's my first objection is he filed I'm sorry.
How would he know? I mean, if you didn't file that to the 24th, how would he even know 7 days ahead of time that this hearing was going to be today?
Because we set this hearing on January 11th, 2021.
Prior to you filing for relief?
So this relief that they're referring to is our second amended motion. So the first amended motion was filed back in July of 2020, and we set this for hearing in January of 2021. And in fact, just so the court is aware, Mr. Younger on March 24th filed a counter petition and set his own temporary hearing for today. So Mr. Younger filed his own motion that was set for today as well. So both sides had temporary hearings today at 1:30. Does that clarify the timeline?
Yeah, I guess so. The affidavit, though, that was attached to your amendment that was filed on the 24th, is it the same affidavit that was filed with your original filing back in January?
So about 98% of it is. The only updates to it are the things that happened between July of 2020 and March of 2021. So otherwise, yes, it's mostly the same affidavit. The events that they're talking about, though, and this is my objection on the waiver issue, is the events that they're talking about occurred back in August of 2020. And Mr. Younger himself today testified to the court that he knew about the protest before it happened. I'm not alleging that he was there at the protest. I'm not alleging that he went to the protest, but he knew about it ahead of time. He knew that people were going to protest, including his girlfriend who lives with him. He knew that. So if he knew that back in August of 2020, why did he not file this alleged recusal motion? Why did he not file that until March 26th, 7 months later? And so that's one of my objections under Rule 18A, subsection B, subsection 1, is that he knew or reasonably should have known about this back in August and never filed any kind of recusal motion whatsoever.
When you say this, what are you referring to?
The August 30th, 2020 protest. That again, no one is alleging that Judge Brown has personal knowledge of any of this. It was simply utilized to show a history and pattern of behavior by Mr. Younger, that when something doesn't go his way, he supports or his supporters organize these protests using images of his own child on a Facebook page that is administered by his friends and family. And so that's part of the issue today with my objection, is that Mr. Younger, if he thought that this would have led to a recusal, then he knew that this protest was going to happen outside of Judge Brown's house back in August of 2020. And he waited 7 months until one business day before our hearing to actually bring this up to the court. I would also like to point out, Your Honor, that I've asked for sanctions against Mr. Younger under Rule 18AH, as we absolutely believe that this was brought in bad faith, as the motion itself does not even allege any facts whatsoever to support the recusal. Mr. Younger has no facts to support the recusal. Dr. Georgelis did not provide any facts to support the recusal. And we were supposed to have a hearing at 1:30 today, which I absolutely disagree with Mr. Jackson. There's not an emergency. There are 2 children in the middle of this that can't get counseling. And that was part of what we were trying to hear today in front of Judge Brown, is to get some counseling orders for these children who were ordered to go to counseling a year ago. And so I certainly believe the court has the ability under Rule 18AH to grant sanctions, and we're asking the court to grant sanctions against
Yes,
Mr.
but he's entitled to have a hearing on that and have notice of that hearing.
Understood.
So to the extent that you're claiming that the notice was contained in the pleading you filed today, I just don't see that as being adequate notice. So if you want to pursue that, you're going to have to file a motion for it and set it for a hearing with sufficient notice to Mr. Jackson.
Understood, Your Honor. And what I would say to the court is, if that is something, I do not want to delay any of these proceedings. So I will waive my request for sanctions. I filed it as soon as I could, but I completely understand the court's position on that and don't disagree. So I will waive my right to do that. I would like to make one last point, if it's okay, and then I will be quiet. I would like to point out, Your Honor, that I've never had a situation like this where a party and that person's basically supporters and church friends and girlfriend can go attempt to harass a judge at their personal residence and then use their own bad behavior to try to recuse that judge. If that were the law under these recusal motions, literally anyone could stop a judge going to their car and try to talk to them and then say, oh, they recused. It's the worst form of forum shopping. And so for all of the reasons that I have mentioned and all the evidence the court has heard, I would just respectfully ask the court to deny the recusal motion. Thank you.
Mr. Jackson, rebuttal. If you don't mind, I'd like to spend the rebuttal with you asking a few questions.
Sure.
So I guess here's what I'm struggling with, and maybe that's where you can help me. On the motion to recuse, the provision you're relying on is 18A-B. Let's see. I'm sorry. 18B sub B, grounds for recusal, and under that, subparagraph 3. The judge has personal knowledge of disputed evidentiary facts concerning the proceedings. And in the motion, you specifically state out, you say, paragraph 3, respondent disputes the allegations set forth in paragraphs 2A, B, and C set forth above, specifically, and then you identify 4 areas, A, B, and C. I'm sorry, A, B, C, and D. That he did not tell the supporters about the location of the activities, that he had nothing to do with any directive on Facebook, that he did not organize the attempts to have ex parte contact, and he has not supported organizing attempts to provide ex parte contact. So I guess the question I have is, a lot has been mentioned in the hearing of the protest outside the judge's house. But the fact of the protest does not seem to be a disputed fact.
I would agree with that.
Okay, so what seems to be the complaint that your client has is that he didn't tell the supporters about the location of the activities. He didn't have anything to do with what happened with Facebook. And I'm paraphrasing, he did not organize attempts to provide ex parte contact, and he has not supported any organizing attempts. So the question I have is, why do we believe that Judge Brown would have personal knowledge about whether or not he himself put anything on Facebook, or he himself participated in the organization, or he himself told supporters about the location of the children's activities? Because that seems to be the complaint, that he didn't do these things that it has been alleged that he's done. But I don't see how the judge would have, where is it that we can extrapolate that the judge would have personal knowledge of that?
Well, the allegation is that he's attempted the ex parte communications and bullied and attempted to coerce the court. And I'm paraphrasing there as well, Your Honor.
But I don't think there's any dispute that he wasn't there.
Well,
he said he wasn't there, and his former wife said she saw the video and didn't see him.
Right, but my point is that if Judge Brown has knowledge that he was indeed involved, or that it's her understanding, or she was told by one of my client's agents who might have been, or somebody that she perceived to be an agent at the hearing, communicate that they were acting on his behalf. If she received communications from persons who purported to be agents of my client, those would,
But why do we believe that may have happened? I haven't heard any facts that would indicate that might have happened.
well, I think the fact that they pled that my client did indeed do this, they're the ones that actually made this an issue. And this addresses Ms. Janisek's last point, that if what my client was doing was the worst kind of forum shopping, he'd have done this back in September of 2020.
Right. But judges hear allegations from opposing parties all the time.
Absolutely.
That doesn't give them personal knowledge of whether or not the allegations are true or not.
I understand that, but in light of the fact that this allegation is that my client was, my client's supporters were actually outside the judge's home and interacting with the judge's husband.
But that doesn't seem to be in dispute.
Well, that part doesn't. I believe Ms. Janisek mentioned earlier that my client's fiance was present, which that's disputed as well. But if there are people there that the judge appeared to take as agents of my client.
But there's no evidence that the judge was even home.
Well, I know that's why we need her either testimony by deposition or at a reset of this particular hearing. And I've already said from the get-go that she's, again, she may be able in 5 minutes to make this entire thing a non-issue by her testimony, or she may in 5 minutes provide evidence that does show that she has personal knowledge. But we won't know without being able to actually engage in that particular brand of discovery, which again would be minimally intrusive and painless.
But I don't want to grant discovery on the basis that, well, we don't know what she knows, so let's just find out. There has to be something that more than that.
Well, I would submit that in light of the interactions between the judge's husband and the protesters.
But that's not the judge.
Well, I understand that, but then okay. The fact remains, though, that an independent grounds for potential recusal is now potentially on the table, which has just been brought up live during this hearing.
So let me ask you about that, because that's a different standard. That one would be if so I think it says, if I'm looking at the one is grounds for recusal, judge must recuse in any proceeding in which, and you go down to number 7, the judge or the judge's spouse, and then you go to C, is to the judge's knowledge. And again, it's tied to the judge's knowledge. Does the judge have knowledge that her spouse, her husband, is likely to be a material witness? And if he came out, all I've heard is he came out to talk to the protesters and tell them they can't be on his property. So, how would that, nobody disputes that they were there. So how would that make him material? Well, meaning, because I would assume there was a lot of witnesses that could say the same thing. And how would it make it likely?
Well, with respect to the materiality of it, the petitioner is the one that made this. She had mentioned in her argument earlier, counsel had mentioned that the motion is 98, or the pleading is 98% the same as it was in the previous incarnation of that pleading before it was amended. That 2% that's been added are these allegations with respect to the protest. Now, the allegations are that the protests were calculated to be ex parte communications, bullying, coercion, and the judge's husband, and again, the judge may have witnessed it through the window, or I don't know what the judge herself knows, but if the judge's husband went out on the front porch and saw the protest.
Well, we don't even know if the judge was home.
Correct. I agree with that, Judge. But what I'm getting at is that with respect to her husband, I think the question is, why would his testimony be material? We all know that the protest happened. But he would be
a lot of people there who can testify as to what he did or said. He's not the only person who's the guardian of that information. There were many people there.
Well, I understand that, but he's uniquely situated to be able to determine whether he felt that it was a threat or coercion toward the judge. And he was a party. And I have no idea. He's the only person I know of who actually communicated with any of the protesters. So as far as if you were to say, Jackson, who at that protest do you know of that you can point to that knew what was discussed between the judge's husband and the protesters? The judge's husband is the only person that I would know of that actually fits that bill. And my point is that if this is material enough to make an issue of in the case, which again that was the petitioner's doing, it's material enough for us to at least find out what this looks like. This we haven't had the hearing yet. And so again, if you just take it on its face, the the allegation is that my client's having ex parte communications with the court and trying to bully and harass or coerce. We're simply trying to find out if that occurred. Now we're also simply trying to find out if the judge's husband has material information. And again, we're not seeking a long delay. We're not seeking anything other than enough due process to actually find out what a witness might know. May I briefly respond to a couple of the points that Ms. Janasek brought up?
Sure.
She said this was the worst kind of forum shopping, because if our motion were to be granted, this would give anybody that wants a new judge. And
Yeah, no, I understand your point. If it were granted, you have no idea who the new judge is going to be.
well, not only that, if that were our motivation, we would have done this a long time ago. The protest was back in August. If we were going to, or if my client was going to stage a protest just to get a judge kicked off the case, he would have filed this back in earlier mid-September without having this issue. I mean, I can read. I'm not the greatest with the Queen's English, but I can read Rule 18A enough to know that it'd be nice to file this kind of thing more than 10 days before the hearing.
Yeah, and I was going to ask you, what about her argument it's untimely?
Well, that's what I'm getting at, is
Okay.
if this were the plan, this has been done a long time ago, Judge. The bottom line is, though, is that we didn't know that this was going to be a linchpin or an issue in this case until maybe I'm a little slow, but I hadn't been on the case that long either. And I know Mr. O'Neill's not slow. This wasn't a big issue in the case.
I can take judicial notice that none of the counsel in this case are slow.
But
That helps.
thank you. That's very generous on my part. But with respect to using this as a tactic, motion would have been filed a long time ago if this were an attempt to recuse Judge Brown because she's biased or prejudiced. And significantly, we didn't allege bias and prejudice in our motion. This is not a motion where we went in and said, oh, she's all against our client. But when a petitioner puts this in a pleading that it's a significant issue, and it's a pleading that the judge either presumably has read or will read, we'd be remiss not to go, okay, well, now the judge is a witness. And so as far as the timeliness goes, the rule clearly says 10 days before the hearing, unless before that day, the movement neither knew nor reasonably should have known the ground stated in the motion existed.
So what ground grounds are you identifying that you only became aware of on March 24?
That the allegation that my client attempted to ex parte and coerce the judge by virtue of this protest.
And how would she? What evidence have we looked at that would raise the question that she would know that he was behind this?
Well, with respect to,
I mean, I know the opposing parties alleged it.
right.
As I mentioned, parties allege things all the time. And of course, judges are aware of that because they read pleadings and affidavits. But how would she independently, what have we heard or seen that would lead us to believe that she independently had personal knowledge of that fact?
Well, we don't yet, but that's what we're trying to find out, if the court would give us permission, either with the subpoena for the deposition or the actual testimony. If there has been an ex parte communication or someone has purported to speak on Jeff's behalf or further his goals to the judge, if there was somebody the judge perceived to be an intermediary, she would be uniquely in possession of that information. And so, again, that's That's why we need her testimony to establish that. So what's been said today to raise that issue? Well, we do have evidence clearly that there is and was a protest. We have evidence clearly that there was some exchange between protesters and the judge's husband. We have allegations that, again, judge may have read this affidavit already in preparation for this hearing. And, it's almost like, you have an allegation like that the only way we can respond to it, if the judge has indeed read and curiously, and the family code provides that pleadings in cases like this will generally be somewhat dry, somewhat devoid of facts to avoid airing significant quantities of dirty laundry in family lawsuits, because family lawsuits are particularly vulnerable to all sorts of airing of grievances in pleadings. And so the family code clearly contemplates pleading generally. Here we have a pleading that's filed just a few days before a hearing that injects, I don't know what could be a more inflammatory allegation that the judge has now read, the judge has now looked at, the judge has read our motion for recusal, presumably in declining to recuse. So, and, no matter how good a judge is, they're human. And so now we've got a judge that has been, that has read a pleading that accuses our client of trying to bully and ex parte and coerce the judge. As I said earlier, I'm loath to even to file motions to recuse judges, particularly judges that have been judges longer than I've been practicing law. But we had no choice, but the only way to find out is to have the ability to do the very, very limited discovery, or not even discovery, just subpoena her to testify for a few minutes at a reset of this hearing.
All right. Anything else from either counsel? All right. So based on the evidence and the argument and the pleadings before me, to the extent that I have been requested to enter an order allowing a subpoena of the judge to testify for this hearing, I'm going to decline to enter such order. I've already denied the motion to continue at the beginning of the hearing. I'm also going to deny the motion to recuse the judge as filed on March 26. And since the respondent has withdrawn their request for sanctions, no ruling is necessary because that matter is now moot. And I will have an order to the clerks this afternoon reflecting the decision to deny the motion to recuse. Anything else that we need to take up before we adjourn?
I have nothing, Your Honor.
No, Your Honor. I guess the only thing we need to do is, and I ask this because it's Zoom, is we need to get with the coordinator with Catherine. Hi,
I'm
Catherine.
here. Hi.
And what we do from here.
All right. Well, then, from my standpoint, the hearing is now adjourned. Catherine, presumably you can keep the people you need on Zoom to work through any future issues.
Yes, Your Honor.
Right. The rest of us are excused.
Thank you, Judge.
All right.
Thank you, Judge.
Actually, Judge Jordan, could you stay for a moment?
Just barely caught me. I had one more click.
Okay, well, and the
Go
respondent
ahead.
just clicked off because we do need to order Mr. Younger back.
Well, we can get him back on, I believe, Catherine.
Okay.
Still need me?
Can you wait for a moment?
Sure.
Because I don't think we're not going to have the hearing today, so we need to talk about dates.
Yeah, and I think he's got to be, Mr. Young's got to be sworn back in since there's an enforcement.
Yeah, but I'm not going to hear that.
Correct.
No.
Correct. Judge Brown will hear it. So are y'all available on April 14th? It's a Wednesday.
I need to grab my calendar. Can you hold for just one moment?
Sure.
I can make that happen. And I apologize. I'm going to take my jacket off because I am almost 8 months pregnant and having a hot flash at this point. So my apologies. Okay.
Since we're not in a formal hearing, I don't think you need anybody's permission.
I know, but old habits die hard.
Catherine, I'm in trial on the 14th. And
What about the afternoon of the 15th?
I'm in trial on the 15th too. That entire next week other than Monday's great.
The week of the 19th is what you're talking about?
Yeah, Tuesday through Friday is wide open.
And I've got some stuff, but I think I can move anything Tuesday through Friday.
So the 23rd y'all could do?
The Friday? Yeah.
Friday the 23rd, 9 o'clock?
Yes. Will it still be on Zoom, Catherine?
Yes. Yeah, we'll still be by Zoom.
Okay, then yeah, I can make that work.
Okay.
Dr. Georgia, can you make that work?
Yes, I can.
Okay.
Logan,
I'm available.
Okay. Mr. Younger, yes?
Yes, ma'am. I can do it.
Okay.
What time did you say, Catherine?
9 a.m. on April 23rd.
Got it.
is that for the first half of the day, Catherine?
Yes, sir. I had a set for 3 hours. Is that still?
Yes, I think that'll do it.
I think that's.
So Judge, we just need a order to appear for the respondent, Mr. Younger, for the 23rd at 9 a.m. If you could swear him and order him to appear on that date, we're good.
And Jessica, I was going to say since Judge Jordan was just appointed, his assignment's limited to the recusal. I'm afraid that if he.
Oh.
I'm okay, Craig. I mean, I'm okay if you just agree that he's going to appear. I mean, it's on Zoom anyways. I can't put someone, I'm not asking that he go to jail or anything like that. I can't do that on Zoom anyways.
Well,
So.
I was going to ask you if you were seeking contempt, then we could figure out a way to get him in front of a judge once the order of the order declining the recusal signed. But he's going to be there. I mean, if he's not, he'll be at the hearing. So we can do something to assure that if you need further assurance.
That's fine. I trust you on that.
Okay.
I would say that Mr. Jackson's correct. The order of assignment is limited to hearing a motion to recuse.
Yeah, if it said anything else related to this case, then maybe there'd be jurisdiction, but I don't want a jurisdictional issue on that.
Okay, so are y'all good, or do you want me to get Judge Brown to log in and order him back?
I think we're good.
I'm okay with that, Catherine, because we can't do jail
Okay.
time or anything, so I'm okay with that.
Okay, all right, we'll see y'all April 20th.
Thank you, Judge, for your indulgence.
Thank you, everyone.
Thank you all. Thank you
Thank
very
you.
much.
Have a great day.